All right. Hello again. This is Ben Hitchcock Cross talking to you today. Um, we're just going to go over, sort of recap the Judge Borowski decision there, um, and just talks a little bit about the powers and the elements and mandamus and things like that. Just as a refresher there. And we'll go, I think, from there. I think it'll be interesting. Couple of things that we need to keep in mind. Number one, I am an attorney. We could do bias check. I'm an attorney practicing in Milwaukee County. In fact, across the freeway from Judge Borowski. Even if I did or did not have cases in front of Judge Borowski, I do. Um, even if it wasn't a writ of mandamus or any other thing, I need to explain to you that believe that I'm not to criticize, directly criticize sitting circuit court judges. Um, and we can get in a little bit to what that means, but I can also tell you that it's not in my best interest to criticize a, or I should say more importantly, it's not in my client's best interest for me to criticize the decisions of a circuit court judge. Um, and that's an interesting word, and we'll try to parse it as much as we can. And I get that. Um, and there's probably other reasons beyond that as well. So we're just, we like to talk about. We take that page from Mormon Stories podcast, and I think doing a bias check is always a good idea. Just let it all hang out there. So that's something that you all should keep in mind. The following statements that I make. Number two. So and I guess, sorry to back up. You're not going to hear me say that I think this is a good decision or a bad decision, and that's trying part of what I'm trying to um, thread here for a couple of reasons that I've explained, and others that probably haven't, as you know me. Okay. Let's back up though for primary purposes here. Writ of mandamus. What are they asking for? What do they get? What does that mean? What's our test? Okay. So the law, clear legal rights, positive and plain legal duty, and damages. Right. Okay. Now we start with damages in reverse order because that means that you got to be the one to have some harm. And we talked about this earlier in a different video here that's not playing right there now. They've got uh the will the Wisconsin Institute for Law and Liberty has some parents that went to it and said, "Hey, we're not getting school resource officers in there." I don't I assume that uh, these people came to Will and said, "This is what the problem. We need a lawyer. I don't want to pay." They went to somebody or had problems finding. I have no idea when you sit down and say, "Oh goodness, I'm going to look to Will." I mean, I assume when you have a legal problem and you don't have money that it takes to pay it, and not like anybody would. Um, so okay, um, yeah, they went to them. Then we're talking about positive and plain legal duty. Now, part of the issue here, remember, is that there's this statute that says basically there shall be these resource officers in the schools. And without going too far into the weeds here, there's this argument about there's a couple of arguments here, and we've all seen the one where it's like, well, these when they say officers, what do they mean by officers? Because we have these standards here for officers. Okay. And I thought that was one of the clearest um, parts of the decision that the judge made. And um, I don't actually know what happened because I haven't checked the CCAP on that. But normally, a judge will do two things. In circuit court, they will say their order and then they will write it down. Okay. Many times they've already written the decision and order out, and they're speaking it is just for the benefit of, I won't even say theater, but it's for um, I mean, I think it's extremely helpful. I think it's extremely helpful on all sides. And sometimes, if it's super contentious or whatever, it's extremely useful for the parties to hear what it is the judge has to say, as opposed to just reading what the judge read. Because some people, but also I think, just we're all learning the law here, and I find it. I've always found an oral decision to be extremely helpful in understanding. Extremely helpful in understanding. So that is that. It's also no doubt a chance for the parties that, if there's some argument ahead of time, for the attorneys on both sides to show what they know, and for the parties to understand that they're getting their money's worth. Okay. Should have got more coffee before I did this segment. All right. So that is why there is this. That's why he's giving this oral argument here. Okay. So he's going through some of these decisions. The way that I read it, it seemed to me that he was giving his oral decision and then going to write it out afterwards. And then, although he clearly had thought about it, he clearly knew the cameras were going to be there. Why? Because he gave permission for them to be there. Okay, right? You can't film in a courtroom unless in Wisconsin, unless the court gives you permission to do it, and you have to file a motion with them, and they can just deny it if they want to. Um, and then we are going to get back to this concept here, but that whether or not something is filmed is in within the sound discretion of the court. That's the phrase we use here, which basically means that unless there's evidence to show um, an improper purpose or a mistake, it basically we're all going to defer. It's whatever the judge wants, to put another way. But the appeals courts are going to defer to the lower court. Is another way of putting it. Okay, and that's interestingly enough the standard for mandamus, right? It's within, as they say, the granting of an extraordinary writ, of which there are several besides mandamus, like supervision and um, habeas corpus for others, are within their common law remedies within the sound discretion of the court. That sound word there is just to mean putting that, like, as opposed to sound mind and body kind of thing, meaning that it's justifiable. And I think that's probably a better way to put it, under the justifiable discretion of the court. Yeah, that's pretty good. Okay. So, which is going to be extremely, extremely important here. Okay. And as I talked about before, I thought there was some really good um, arguments as to training. Now, the judge dispensed with that very quickly, right? He's saying, I think the training can be summed up, like they have all this training already, but I think they can be summed up as go to the schools, interact with the kids, talk to the principal, do your job. I'm paraphrasing a little bit, but that was his argument and or decision. I should put it like that, because that's the right verb. So that's that argument put away. Okay, another one is who's going to pay for it. And I'll confess on my end, I'm a little bit baffled as to why the city should have to pay for it at all. I can tell you that I haven't read everything like it's my case, but I have skimmed things enough to still be having asked that question 2 or 3 times, which is I don't understand why the city would be paying for it. Okay, and there's 2 reasons of why. Number one is something that the judge mentioned, which is that this law didn't come out of nowhere. It wasn't exactly imposed on the MPS. It was the product of a negotiation, which is a little bit weird to say because the Republicans have the majority and they can impose things, but for whatever reason, there was a compromise. Okay. And that was alluded to there in terms of like this people already knew this. Okay. But Now, the law, and I think this was another point too, is the law didn't say MPS shall put them in there. I think it says there shall be uh, SROs in the schools. And so that, yeah, I just don't get it. And that's why, meaning I don't get why anybody other than in anywhere in that statement, why the city of Milwaukee would be, well, all right, I take it back. All right, I take it back. I can see that. The problem is ultimately, and this point was also made by the judge, is that the how what's the best colloquial? I can't think of a good colloquial phrase for it. Either way, it's still the city of Milwaukee, and the levy of the taxpayers, meaning I and Whitefish Bay are not paying for, well, directly. I'm not paying for this, either of this, the officers in any way. Okay, I'm not. Okay, so but the people who pay property taxes in the city of Milwaukee and other taxes which possibly go to the city, um, they are paying those directly to the city of Milwaukee in terms of the levy for the schools, which remember has its own levy, which was increased, and the city, which has its own property tax levy. So they're paying both of those numbers. And you know, 600,000 divided by 2 million divided by 600,000, we're talking like $5 a person. So it's not a big deal necessarily. Um, but there's some what I'm saying is, I don't think it would have mattered if the judge had said 75, 25, 100%, 0%, whatever. And that being the case, you might as well say 50-50 because um, that's going to seem fair. Now, that's going to lead me to segue into this other section here about equity. Okay. Now, equity has gotten a bit of a bad name here lately, um, which is maybe fair, may not be fair. I'm not going to address that. What I'm going to address is this: a circuit court judge, superior court, whatever your name for it is there, but a court of record in Wisconsin has equitable powers. What does that mean? Uh, okay, there used to be courts of equity and courts of chancery. We're going to skip much of this historical lesson, and we have talked about that before. But that there used to be a court that could only basically follow statutes and laws, and another court was sort of a court in fairness for resolving lower level civil disputes. The other one's enforcing the king's law. The other one's more of like a people's court. Yeah. Okay. The yeah. So these equitable powers, some have been strictly kept separate. There's sometimes they're kept separate in some areas, and but generally speaking, in Wisconsin after the 1973 reforms, all courts have all those powers, both statutory and common law. Okay, and again, some of the common law powers are these equitable powers and principles. Okay, what does that mean? That really means that somebody can, because of some action of somebody, take something and give that to somebody else. Okay, or decide what the property is in equity, meaning here's what that really means. Okay, that means it gives a court latitude to make decisions and draw a line. That's basically what the best way I can put it. Now, and we say because of fairness, but that's from Roman law and other law, there's a series of maxims and phrases that let us understand what equity is. Okay, and you might, I'm not even going to get into them because I'll be rattling them off for the rest of the day. So, what is the point of that? That again, that means that the judge, and what was the issue there? Judge says, hey, there's a gap in the law, which means it doesn't say who's paying for it, the city of Milwaukee or the school system. I don't know why it wouldn't have been that would might have been something I would have raised. Well, hey, if it's the city of Milwaukee or the school system, why can't it be the school of Milwaukee or the state of Wisconsin? Just saying. Okay. So he's saying, Hark, I identified a gap in the law. And he said something like it's our job to interpret, not write the laws unless there's a problem. And that's, I mean, it's a fair defense of what he's doing. And what he's doing there, to be clear, is absolutely within, there's just, I mean, there's like no question about it. And what it means is this: there's an ambiguity in a contract. Okay, we don't know what the contract means. It says if someone, something in a contract is up for dispute, and I read it, and it could be in favor of Mr. X. It could also be in favor of Miss Y. Okay, that's an ambiguity. It's capable of more than one meaning. When legal documents, when we're writing legal documents, we want them to not be ambiguous. Bam. Okay. So no problem. If a law is ambiguous, then a court can try to interpret its meaning. We have a whole bunch of rules on how they're supposed to do that there. Okay. And he's basically saying, and actually, I have no idea one way or the other if it's right or wrong, is there's no um, way to determine who's going to pay what. Okay. So somebody needs to do it. And I'm going to use, equitable principles to determine 50-50. That, that's within his powers. Okay. Which is where we're going to get to the final part that we're talking about, which is the discretionary power to do this. Okay. And I'm going to draw your attention, I believe, to the first section there when the judge is talking about what he says are the ills of Milwaukee. Okay. No doubt we're a great city, and he says that, but he also says um, homicides, domestic violence homicides, um, violence in schools. I'm sorry, I'm struggling here. He mentions other ills of in Milwaukee, but not just ills that have been that politicians have turned a blind eye towards. Okay, and that may be a political statement. I don't know. My point is here is that he then says that other judges may sort of allow this to slip, but not me. Okay. Now, is that a statement of self-aggrandizement? Maybe not. Is it a justification? He's got to justify, and you'll see that he does that in everything there, because any judge is going to. I mean, that's part of being a judge. Um, but what he's describing is the use of his discretionary power and exercising his discretionary powers. Okay, and that's that's what we're talking about here. Which that means again, it's in the sound discretion of the court. I think in Milwaukee County there are 32 judges. They're not all 32 assigned apparently to do writs of mandamus, but you are flipping a coin, and it could be any number of judges there who are any number of um, tough, not tough, nice, not nice. I don't. I mean the whole gambit of personalities, politics, and I don't know persuasions are um, elected to the Milwaukee County Circuit Courts, and there are certainly enough Milwaukee County judges that there is, um, I guess, a judge for everybody. Now you only get one judge for your case. So that in and of itself is a huge factor of luck, um, one way or the other, and how this would turn out. And it's what I'm trying to say is it's possible that a judge could come up with the exact same circumstances. Not only not if you think this judge was yelling at MPS, but not even not yelling at MPS, not being forceful with them, but not even saying, "Hey, you have to do this," or giving them 6 months, a year, 2 years, all sorts of things to do this. Okay, this could have been there could have been completely different approach to this, and that needs to be understood and recognized that this is an action that this person who is, although they have powers here and discretionary powers, they also are elected as a position here. So I think those are all the factors, I hope that I've explained that, um, at play in this decision, and I hope you got some value out of it. All right. Thanks for sticking with us. I think I got everything. We'll keep you informed.